We'll just get started. So, as you guys figured, the California legislature and Gavin Newsom have been really busy at the end of 2022, and they've really given us a bunch of new laws to look at. So we're gonna jump right into it and review what those laws are, make sure that you guys are aware and are compliant. So let's go over the bills that are the most important ones. So the key one that is important, and I'm sure you guys are aware since we're already almost mid-year, as of January 1st, the California state minimum wage was increased to $15.50 as to all employers, and this increase was regardless of employer size. You can expect that as of July 1st, 2023, the minimum wage for the city of LA is going to increase by 74 more cents to $16.78 for all employees. Again, it's going to be regardless of size. And I have a lot of clients who basically say that doesn't apply to me because I don't do any business in the city of LA. Well, if your employees perform at least 2 hours of work within the city of LA geographic area, then they're covered. And so you want to make sure that you are properly compensating those employees for based on the city of LA minimum wage. Additionally, as of July 1st, the minimum wage for the county of LA is also going to go up to $16.90. And again, it's specifically for those employees who perform at least 2 hours of work for the unincorporated areas of Los Angeles County. So again, you want to make sure that you understand the county lines and the boundaries and check your address to make sure that you are compliant with the minimum wage requirements for the city and the county. Now, if you are in the city of LA, then that local minimum wage ordinance is going to trump the county. So in this situation, that's important to understand because the county happens to have a higher wage, which is unusual. Typically, the city of LA is the highest one, but in this situation, the county of LA is actually higher. So let me know if you have any questions about that. So we went over the city of LA, and I just want to emphasize that it's important for you to check not just the California minimum wage, but the local ordinances for where you are operating. And currently the city of LA minimum wage is $16.04. We just recently went over the California minimum wage, which is $15.50. The city of LA is $16.04, and then there are other local ordinances. If you have specific questions, feel free to reach out. So we're just going to keep going here. Make sure that you also understand that with respect to exempt employee salary, that is also going to be updated according to the minimum wage increase. So just keep track of that and understand that as the minimum wage goes up, if you have any exempt employees who are in the administrative, executive, or professional exemptions, their salaries are going to go up accordingly. So double check to make sure that those are correct as well. And also make sure that, as always, that they are performing the applicable duties that make them an exempt employee. So, one of the things that has really been confusing a lot of people is this pay transparency, SB 1162, which has all sorts of requirements for employers. And I think that a lot of my clients are certainly confused about what all of this means. It essentially amends and expands California pay transparency requirements. So you want to make sure you understand what all this means. In a nutshell, when an employee asks for information about their pay scale, you're supposed to disclose it. I will tell you that it's clear as mud as to how you're supposed to disclose it. So clients have been allowed some flexibility. Some employees want this in writing. Well, it doesn't really state that you have to disclose it in writing. You know, so others are asking for information for their anyone who is in that category. Well, again, it's not really up to the employee to find out what other employees are making. It's about their current salary. So it's whatever the employee requests, and you have some flexibility as to how you provide that information. And again, I think it's key for you to keep confidential everybody else's information, because that's not what this is designed for you to disclose. It's only pertaining to the applicant and to the employee. Okay, so again, if you have questions, let me know. Otherwise, I'll keep going. And there are some requirements. There are buckets of this law that apply to employers of specific size, but you got to understand that this initial level of it is essentially applicable to everyone, okay, to employers of all sizes. And then we sort of go down as to who the next one applies to. This next one category is, so sorry, let me backtrack. I'm kind of getting ahead of myself. So the act also has a record keeping component. So essentially you're required to keep a record of the specific job title and the wage rate history for each employee throughout their employment, plus 3 years after the employment ends. And this next one, essentially, this category of requirements applies to employers with 15 plus employees. So it's kind of, it's the first requirements plus, if you're 15 plus, it's this one as well. So you must include pay scale information in job postings. Even if you're posting on any website, it doesn't matter what it is. It could be LinkedIn. It could be some website no one's ever heard of. It doesn't matter how unknown it is. If you're posting out there, you've got to include the pay scale information. And again, this is clear as mud, because there's all sorts of questions as to, well, am I supposed to be including the pay scale information for where they currently are, or what the range is, or maybe their performance and their experience puts them at the bottom part of the range, right? So it's all sorts of questions that I'd be happy to answer, but as of now, just make sure you understand what these requirements are. And if you are using a third-party vendor to post information for you, make sure that they are also abiding by the pay scale information requirements. This final layer of it is essentially applicable only to employers with 100 plus employees. So it applies to larger employers. And it essentially just layers on your reporting requirements and all the paid data reports that you've been doing. It essentially layers on additional criteria that I would be happy to answer questions about at the end. So there are financial penalties for employers who are larger, the largest category in this law, 100 plus employees. And if you do fail to abide by the requirements, if you're that larger employer, then you'll face financial consequences. So you should be aware of that it do have the way to enforce it. I also want to talk about leaves of absence updates. California continues to expand its array of protected leaves. Who knows what they'll come up with next? But bereavement leave is now a protected leave beginning January of 2023. And it is expanding essentially the persons that an employee may care for. And we'll also talk about the expansion being applicable to CIFRA and California paid sick leave. So let's go over those, both of those expansions now. So with respect to bereavement leave, we're basically now it's now basically protected. And the requirement applies to all employers with 5 or more employees. So if you're under 5, it doesn't apply to you. The leave may be unpaid. So it's not saying that you have to now pay for it. It's just saying that it's protected leave. And so you must provide it. So some clients who have historically provided 3 days of bereavement leave and paid for it can continue to pay for it if they want, and just add 2 more days that can be unpaid as long as you're providing at least a total of 5 days. Okay. And the other aspect of it is basically that you go back. It's essentially redefining some things. So the designated person is now defined as a person identified by the employee at the time the employee requests the type of leave. And again, it's clear as mud, and it's right now, I'm sure, going to come down to whatever the courts want to turn this into. But at the end of the day, I think that, you know, my advice is keep it, be as flexible as you can. And as long as they request it, give it to them. And if there's a situation where you suspect that an employee is taken advantage, that's something that should be addressed on a case-by-case basis. But otherwise, I tell my clients, err on the side that you need to provide it, if, you know, especially if they're asking for it, and make sure to document it and make sure that the designated person fits the definition to the, you know, the way that it is written, even though it's pretty broad. Okay. Wait, let me go back. My slides are a little out of whack. Okay. So now let's go to the next one, which is the California Family Rights Act, the CFRA. And so this one basically, again, it applies to employers with 5+ employees. So if you have less than 5, then it doesn't apply to you. And it's been updated to allow the use of CFRA to care for quote unquote designated person. And this definition is essentially any individual with a serious health condition, which is any individual related by blood or whose association with the employee is the equivalent of a family relationship and may be identified by employee at the time of request for leave. So it's an expanded definition because whoever you're associating with who is the equivalent of a family relationship may not necessarily be someone that is, you know, a mother, brother, aunt, or someone related by blood. So again, I say, whatever you do, you know, tread lightly. This is protected, and make sure that you document everything. The saving grace here is that you can limit employees to 1 designated person per 12-month period for this type of leave. So at least you can limit how many people they can do this with. And there's a requirement to retain records for the designated person along with the dates of the request, which is good for, you know, for both you and the employee. So with respect to paid sick leave, there is also, similar to CFRA, this legislation adds a definition of designated person, and a designated person is defined as a person identified by the employee at the time that the employee requests the paid sick leave. And this one is also has that same limitation to 1 designated person in a 12-month period. So that's some saving grace there. And similar to CFRA, there's a record retention requirement for the designated person along with the dates of the request. Our favorite topic, COVID-19. So let's just, I know a lot of you have I mean, most of you probably already know exactly what you're doing, but I'll just breeze through this really quickly, just to give you an overview. We'll talk about supplemental paid sick leave, exposure notices, and the new non-emergency COVID prevention regs, so you guys are in the know. So as you guys know, the California supplemental paid sick leave expired as of December 31st, 2022. And also the city of LA supplemental paid sick leave and the county of LA supplemental paid sick leave expired February 15th and April respectively, so that you guys know if you're in the city of LA or county of LA, you're done. Okay, so that was that was really important. Some of my clients are really concerned that they still have to pay supplemental paid sick leave. No, you don't. So with respect to COVID exposure notices, you need to still continue to provide those notifications. So if you do have someone who tested positive in the workplace and you've had close contact, another employee had close contact, you still must provide those notifications. So make sure that you do provide them in writing, but you may now post them in the break room or places where you customarily post other signs regarding exposure. So that's a little easier, but you can still continue to do what you've been doing, the way you've been issuing them, whether it's a physical copy or via email.
Kristina, can I pause? I'm going to pause the recording. Thank you, Kristina. Take it away.
Okay, you're welcome. So we've just discussed the requirement for providing exposure notices. That is still a requirement. Make sure that you post notices in all the places where you typically post all the postings to employees. But you can continue to provide notice via the usual ways that you were providing during COVID. Importantly, if you have employees who speak a different language, you must post those notices in the language that is understood by the majority of the employees. So whether it's English, Spanish, German, whatever the language may be. And you also need to retain a log of the dates that any notices of COVID exposure in the workplace were posted, so that you keep track of that information. And also, I think I want to just track back. It's important that those notices are posted within 1 business day from when you learn of the potential exposure. So that timeline still applies. Now let's just switch and go over the status of the temporary standards, the ETS, that the California OSHA put together. They've been put into place, and as of February 3rd, 2023, they're now in effect. So I just want to go through real quickly and make sure that you understand what those requirements are. So this is in a nutshell. First, some good news for a change. The new regulations removed the need for exclusion pay. So that's gone, okay, which was just basically a free-for-all. You guys can access the frequently asked questions on the DIR website, which basically are pretty useful. And I'll track back for a second. I have them over here. I have them linked over here. So you can type that in or click on that, and you'll have access to these slides after the presentation. So in a nutshell, exclusion pay is gone. The only downside is that the FAQs on the DIR website now suggest that employees who believe they contracted COVID at work, they're being recommended that they file a workers' comp claim with the employer, because basically that's their only remedy at this point, since there's no supplemental paid sick leave. And if they're out of their regular paid sick leave, I think that there's a tendency to go, well, what am I supposed to do, right? Am I supposed to be out on unpaid leave for 5 or up to 10 days? And that is what the way the California, the way the DIR has addressed it is that they're saying that, well, if you're stuck with COVID now, we suggest that just like any other work-related injury, that you go ahead and submit it for workers' comp. Now, knowing what workers' comp is, it has to be, by definition, a work-related injury. So on the one hand, it's bad if it's submitted as a claim, because then your policy rate may go up, right? Your premium may go up. But on the other hand, what's going to happen is that your carrier will make sure to conduct a thorough investigation and shoot it down if they find that it's actually not work related, right? So it's kind of, it's got its pluses and its minuses. There's a new close contact definition based on the size of the indoor space, and I'll have that for you guys as a handout that'll be emailed to you along with this PowerPoint presentation. It's a little convoluted, so you'll see the detailed handout, and I'm sure that you will try your best to understand what it all means. Good luck. But I'm joking, but it's actually, in fact, very, very detailed, very precise description of how you figure out what the close contact is. And it's very precise down to the centimeters and the inches and the space, and, how you determine the cubic feet, and all that good stuff. So the exclusion of COVID cases is still required per the CAL OSHA regulations, but it's now, as Debbie pointed out, really relaxed, because California OSHA has really been working in tandem with the California Department of Health, and so they're kind of like almost at this point they're on the same page, but there was a time when one was ahead of the other, and they were sort of chasing each other. At this point, everyone's on the same page that employees have to be excluded if they have COVID, if they test positive. But at this point, what we're doing now is, as long as they are getting better, their symptoms are subsiding, and they have no fever for 24 hours without any medication, fever reducing medication, they can come back after day 5, and they don't need to test, okay, to return. So in other words, in the past, we were supposed to require that they test and bring a negative test to be able to return to work. Now they don't have to do that, okay? And also they made clear that after day 10, the infectious period is over. So the employee may return regardless of what they're telling you they're experiencing. There's now conclusive scientific evidence that after day 10, the infectious period is over. They've redefined what infectious period is, and I guess we're going based on what that definition is today, right? So that's that. And I also put together some guidelines for figuring out, what you need to do as an employee versus employer, what those obligations are. And so for those who were exposed to COVID, to a COVID-19 case at work, as we discussed, you have to provide notice to those who may have been in close contact based on the updated definition. And then you must provide free COVID tests during paid time to those employees who may have had close contact at work. But there's no requirement for those close contacts to be excluded, especially if they're asymptomatic, right? There's no requirement to quarantine anymore. The recommendation is that they test within 3 to 5 days after the last exposure. And but what is a requirement still is that they are supposed to wear a face mask or face covering around others for a total of 10 days after exposure. If you look at the various local and CDC and CDPH, they're all kind of slightly different in terms of how many days you're supposed to wear the face covering and if you're supposed to wear it at all. I will tell you that I recommend that you follow the California OSHA guidelines, which essentially state that their employee who was in close contact must wear that face covering for a total of 10 days after the exposure, okay? Because they're not being quarantined, and so they're at the work site, and the recommendation is to test on the 3rd day. So in those first 2-3 days, if the employee in fact contracted COVID, they may pass it on to someone else. So that's why the face covering is important, because it basically is a preventive measure for them to spread COVID if they did contract it. Okay. And for those employees who are symptomatic, essentially, we want to isolate them because if they are exhibiting symptoms after exposure, it's likely that they contracted the virus. You want to test them ASAP, and you want to exclude them, and exclusion continues until the test results are obtained. And if they test positive, they're supposed to self-isolate, like I mentioned earlier. And after the 5th day, they can test, and if they want to, but they're not required to. And if the symptoms are subsiding and there's no fever, then they can return as soon as on the 6th day without a negative test, okay? There is a requirement that an employer has a implements a COVID prevention plan. And I do have a template that's a handout. That's my 2nd handout that I'll be giving out to you guys. You receive it as a PDF document. Make sure that you have something in writing as a COVID-19 prevention plan. And CAL OSHA actually just provided a brand new template. So you guys can take a look at whatever you have and make sure that you update it, make sure that it's compliant. Okay. To switch gears, I'm seeing more and more wage and hour and PAGA representative actions than ever before. I've had some clients that have been hit hard in the last 2-3 years, facing more than one class action for wage and hour violations. Okay, so as an employer, I want to make sure that you guys have your policies in order and practices are compliant, because having a policy is one thing, but having a practice that's in conflict is the written policy isn't going to fix. So make sure that you understand what the meal and rest break requirements are in California, what the overtime requirements are, and understand how meal premiums and rest break premiums are paid. There are some additional developments that I'm not going to go into today, but we'll probably present likely as a webinar on another date. But I want to make you aware of the Naranjo decision that the California Supreme Court confirmed that the 1 hour premiums due to non-compliant meal breaks are, they constitute wages under California Labor Code. So failure to pay those essentially triggers a penalty for unpaid wages. So if you have an employee who is, or more than one employee who's taking non-compliant meal or rest breaks, in other words, they're not taking their meals before the end of the 5th hour, or they're skipping their breaks or combining their breaks, or the breaks are interrupted, those employees are, and they're assuming they're not doing it voluntarily, those employees are entitled to 1 hour of premium at their hourly rate of pay. And if they're not paid that, then you have significant exposure. You know, and if you do face one of these representative actions, you may be in for a very expensive piece of litigation. So definitely be aware that those owed meal and rest break premiums, they can trigger penalties for inaccurate wage statements. That's a derivative type of claim. So in other words, if you didn't pay those meal break premiums, then there is an automatic claim that says that all the pay stubs that you issued to those employees who were entitled to the meal break premiums can now collect penalties because the pay stub does not accurately reflect all the wages, right? And similarly, because those things are now considered wages, and if they were not received upon the end of employment, then the employee is entitled to what's called waiting time penalties. And the waiting time penalty is basically the employee's hourly rate times the number of hours they work per day, times 30 days if they're not paid out within that time, and they're capped at 30 days. So that's a wait time penalty. And if you're doing this with more than one employee, then that really adds up in a class action or a PAGA action. So you really want to make sure you understand what all of this means, and that your policies and practices are compliant. I know I said a lot of things. If you'd like to pause and go into
Resume. It's all yours.
Okay, so we just went in and reviewed the wage and hour case that I think is really important for you to be aware of, the Naranjo versus Spectrum Security Services. But there's additional developments that I'm going to be covering in a later presentation. There's a lot of them, but make sure that you understand that owed meal and rest break premiums are now considered wages under the California Labor Code and can trigger all sorts of derivative penalties. Okay. So I want to move on to this other new legislation, and it's called the Reproductive Health Decision Making SB 523. This legislation affects the Fair Employment and Housing Act, the FEHA, by adding reproductive health decision making as a new protected category or classification. And what this means is that this category may now be included in the existing protected category of sex under the FEHA. And reproductive health decision making includes, but based on this law, is not limited to a decision to use or access a particular drug, product, or medical service for reproductive health. With this next legislation, this is SB 1044, effective January 1st, 2023. Essentially, California law prohibits an employer in the event of an emergency condition from taking or threatening adverse action against the employee, taking any retaliatory action. For refusing to report to or leaving a workplace because the employee has a reasonable belief that the workplace is unsafe. Okay. And this wasn't designed for COVID. It was essentially designed to be applicable to any situation involving, like, if there's a gun threat or a bomb threat or anything like that. Okay. So with some exceptions, employers are also prohibited from preventing any employee from accessing their mobile device or other communications devices to get emergency assistance, which makes a lot of sense with this legislation. This next one is about mandatory retirement savings plan, and we've had this one since June 30th, 2022. But back then it was applicable to more than 5 employers with more than 5 employees. But it's since been extended to now be applicable to employers with at least 1 employee. So they've basically expanded the requirement, and eligible employers need to offer a retirement savings program by December 31st, 2025. And there's it's retirement plan that's ran through either the state-run CAL Savers program or private market option is fine. It meets the requirement. There is an exclusion for sole proprietorships or self-employed individuals and businesses that don't employ individuals other than the business owners themselves. So that's sort of, those are the only carve-outs to that. This next legislation requires businesses to that are open to the public to have restrooms for employees, to allow individuals with certain medical conditions that are listed here to use restrooms during business hours. And I just recommend that you consider training employees on this new obligation to prevent any potential liability for non-compliance. This next legislation requires that the Department of Motor Vehicles allow vehicle location technology. This is all, getting to a point of where technology is taking over. And it allows vehicle location technology on fleet vehicles. And assuming the DMV comes up with such technology, prohibits employers from using the devices to monitor employees except during work hours, and only if strictly necessary for the performance of an employee's duty. So if an employer installs the tracking device on vehicles, the employer must provide notice to the employees of the monitoring. That includes information about the employee's right to disable the device during non-work hours. I mean, it seems pretty commonsensical. Again, if this legislation does apply to you, just make sure that you're aware of it and take a look at the requirements to make sure that you're in compliance. And that's it. That's all I got for you folks. If you have any further questions, I'm happy to take them now. But otherwise, that's the end of my presentation today.
Oh my gosh, thank you, Kristina. I'm curious if people are interested in consulting with you or maybe hiring you, what kind of information would you provide now?
Absolutely. So I want to emphasize that our law firm represents more than 50 nonprofits, and we have specialized knowledge about nonprofits. We work with a lot of nonprofits around the Valley and surrounding areas all throughout California. So I would be happy to first speak with you and see if what your needs are, and have a consultation with you, without charging you for anything. Because I mean, the biggest thing for me is I want to make sure that your needs and the needs of the community that you're serving are being met. And we do offer a nonprofit hourly rate. So I would be happy to speak with you or meet with you in person, whatever your needs are, and go over them. And then together we can decide if there's a fit for us to work together. My contact information is here. There's an email address right here. And this is the phone number to call to contact me, but there's no direct. This is the 986-7561 is the general line, but you'll have to dial extension 116 to get to me. So feel free to give me a call and we can have a conversation, and I can at least steer you in the direction where you need to be going.
I have a question.